Good morning.
Morning, Judge, not yet.
Not yet, okay. Have you heard anything from her?
Judge, I'm trying to contact her clerk, Pietro van Veek, to find out the judge is.
Okay. Let's just wait for some few minutes to let Judge Victor join us. Judge Victor, are you ready?
I'm ready. Sorry about struggle to connect.
Thank you. Advocate Batlenda, you ready?
I am indeed. Thank you very much, DJP, and thank you for accommodating me. Before I commence, perhaps Mr. Du Plessis has indicated that he wanted 1 minute to make an additional point, so perhaps I could allow him to go first.
Yes, Mr. Du Plessis, what point do you wish to make?
Thank you very much, DJP, and I really will be a minute. It arises from the debate in the dying hours of yesterday with Her Ladyship Victor J. around the meaning of Section 238 and an organ of state, which we've just considered a little more carefully overnight. And our submission is that, of course, 238 is an indication in the Constitution of a broader principle that the Constitution itself recognizes that delegations are part and parcel of the modern state. But upon reflection, it's not clear to us that the JSC would in fact fit within the definition of 238, simply because it doesn't seem to us that it is an executive organ of state in any sphere of government. When one reads Section 40 of the Constitution, one sees what a sphere of government is. Our simple point, though, is simply that we were highlighting 238 as a broader example of how the Constitution recognizes delegation as a modern feature of democracies. And we would simply leave with the court then the arguments that we had in our heads of argument to contend that in this case, it was certainly permissible on at least two accepted principles of our law for Justice Mba to have attended. That's either through the principle of implied delegation or the principle of there being a reasonably necessary or implied power. And that's set out in our heads at paragraphs 44 to 47 at case lines 015-325 to 328. And that is all I simply wish to clarify. Thank you very much for that.
Thank you for that, Mr. Du Plessis.
Judge Victor, you covered.
Yes, thank you.
Okay, thank you.
Thank you.
Okay, Advocate Batlenda, you may continue.
Thank you, Judge Dwaba, and thanks again for accommodating me. I should tell you that I was defending a judgment of yours in the Constitutional Court yesterday, so I'm grateful for the opportunity to have done so. Whether I succeeded, of course, only time will tell. So,
yeah, and then be assured, I won't go and inquire as to what is happening to the judgment.
yes, please. Thank you.
Okay, you may proceed.
Thank you, Judge Adwaba. Thank you, members of the court. Members of the court, I appear for the speaker today, together with my learned friend, and we have a very limited role to play in these proceedings. You will know that the focus of the attack and the focus of the relief sought in the original notice of motion and the amended notice of motion is on whether the JSC's decision was lawful, proper, appropriate, and so on. We say nothing on that because the speaker abides that question, and I will therefore not address submissions on that. The speaker's legal interest is limited to prayer 10 of the amended notice of motion, and this court will know that what prayer 10 says is that Parliament, I'll come back to the choice of the phrase Parliament, that Parliament be directed to convene a proper and formal inquiry into this matter in accordance with its powers for the purpose of exercising its obligation under section 177(1)(b) of the Constitution. And you will know that 177(1)(b), of course, deals with the fact that where a judge is to be removed, the National Assembly must adopt a resolution with the supporting vote of at least 2/3 of its members. Now, in the course of this address, I will deal with 3 points. Firstly, I'm going to demonstrate 3 fatal problems with this relief and why it therefore cannot be granted and that the court doesn't even need to get to the merits of the relief. Then I'm going to turn to deal with the question of whether the National Assembly is itself required to conduct an inquiry when there is a potential impeachment of a judge under 177. And thirdly, I'm going to deal with the question of whether a judge has the right to be heard before the National Assembly makes its decision and the Indian jurisprudence that is relied on. But I'm going to submit, and just to telescope the argument, that the applicant's case in this regard does not even get out of the starting blocks, and that is for 3 reasons. And the first reason is that there is really no case made out for this relief at all until reply, and even then there's no proper case. But could I just remind the court, the applicant here filed 2 sets of papers. First, the applicant filed founding papers in which this relief was not sought. Then the applicant filed supplementary papers in which this relief was sought. But in those supplementary papers, there is barely a word on what justifies this relief. And the court will see that this relief is dealt with in only 2 parts of the supplementary affidavit. The first is at 001-603 at paragraph 35.3. And I think I should just take the court there because it is important. I don't know if it would be helpful if I directed the court there. I can do so.
You can direct the court to that.
Thank you. I have done so. Thank you. And there what you will see is paragraph 35.3. Case lines appears to be hanging momentarily. But paragraph 35.3 just sets out what the relief is that is sought. It just repeats the notice of motion, essentially. It doesn't justify it. It doesn't explain it. It just repeats it. So paragraph 35.3 doesn't assist at all on this score. And then the only other place that there's any reference to it is at 001-669 in the same affidavit. And I've directed the court there. There at paragraphs 212 to 214, you will see the section on remedy. And what the applicant says is the court should review and set aside the JSC findings for the reasons set out above. The court should also review and set aside the report of the tribunal. The court must refer the matter back to the JSC for it to deal with issues as required by law. Alternatively, the court must direct that Parliament, in exercising its power in terms of 177(1)(b), must convene a proper hearing of this matter. So what that relief seems to say, and the Speaker explains in her answer that that's the way she understands it, it seems to say that what the applicant is seeking is that the matter is reviewed and set aside, it goes back to the JSC, If for some reason it can't go back to the JSC, presumably because of disqualification or prejudgment or bias or whatever, then instead Parliament must perform that role, and Parliament must itself determine whether there has been gross misconduct instead of the JSC doing so. That's the clear implication of that relief. Now, I'm going to come in a moment to why that is not good as a matter of law, but can I immediately say that what has happened is that our learned friends have abandoned that stance in their heads of argument. Because when you have regard to their heads of argument at 015-204, paragraph 460, that's 460, what is stated there is as follows. In Prayer 10 of the amended notice of motion, irrespective of the outcome of the proceedings, the applicant seeks an order that the National Assembly be directed to conduct a proper and formal process in terms of section 177(1)(b). So we've gone from a situation which said, this is alternative relief if you can't refer back to the JSC, and then Parliament must take over that role, to now saying we want it whether we win or lose. If Judge Hlophe succeeds, we still want it. If he doesn't, we don't. We still want it. And with respect, it's utterly inconsistent with what is stated on the affidavit. But what is stated on that affidavit is important for another reason, because what the Judge President tries to do is he tries to seize on the Speaker's affidavit to make a point out of, with respect, nothing. Because when you go and have a look at the Speaker's affidavit, you will see what the Speaker's affidavit says. And the Speaker's affidavit you will find at 010-1, that's the filing sheet. And then the passage I wish to refer to is at 010-6, and I will take the court there. So at 010-6, paragraph 6, the Speaker says, I emphasize that in opposing Prayer 10, I have a significant difficulty. Judge President Hlophe's supplementary affidavit contains no explanation for why the relief sought in Prayer 10 is justified or appropriate. And then there's quotation of the two passages I've just taken the court to. And then over the page, the Speaker says, I respectfully submit the relief is not sustainable or permissible. And the Speaker says it's not explained. Then at paragraph 9, the point is made that the relief seems to confuse Parliament and the National Assembly, because the relief that is sought is against Parliament. But as we know, Parliament consists of two houses, not one. And 177 only refers to the National Assembly. But then over the page again, at 010-8, is the passage which Judge President Hlophe seeks to seize on. And what it says is, it appears from paragraph 214 of the supplementary affidavit that Judge President Hlophe may be suggesting that Parliament or the National Assembly should be responsible for determining whether Judge President Hlophe committed gross misconduct rather than having the JSC make that determination. Now, that's exactly the passage I've just read to you. If this is the contention, it is unsustainable as a matter of law. The structure of 177 is clear. In terms of 177(1)(a), it is for the JSC to decide whether the judge suffers from an incapacity, is grossly incompetent, or is guilty of gross misconduct. If the JSC does make such a finding, then in terms of 177(1)(b), the role of the National Assembly is to decide on whether to call for that judge to be removed. The duty to determine whether a judge suffers from the incapacity rests on the JSC, not Parliament or the National Assembly. Now that's obviously correct with respect. What the Constitution makes absolutely clear in 177 is that there are two stages. First, the JSC must determine that there is gross misconduct. And second, thereafter, the National Assembly must call for the judge to be removed. Now, there will be an interesting debate one day as to what the considerations the JSC must take into account. What the considerations that the NA must take into account at that stage are. But that's not the debate for today, because that's not the debate that was raised on these papers. The debate that was raised on these papers, as I demonstrated to you in the supplementary affidavit, is could this court, instead of sending the matter back to the JSC, send it directly to the NA to have it effectively usurp the JSC's function? And the answer is self-evidently no, because it would be in breach of section 177 of the Constitution. And that is the answer that the Speaker gave. The Speaker said, if you're going to remove a judge, 177(1)(a) says it's the JSC that must make the finding, not the NA, and you can't bypass that step. But then, of course, what happens is that Judge President then seeks to seize on that. And so you see now there's a huge issue because you don't understand your role and you are trying to say that you are just going to rubber stamp it. And by the way, I've got a right to be heard before the decision is made. Well, that point is not pleaded anywhere until reply. And it is an attempt to make out a new case in reply, a case that is again shifted in the heads. And so really my first point is that there is really no proper case pleaded for Prayer 10, because as I've demonstrated to you, the only way that it is pleaded is unsustainable, and it's now shifted from in oral argument. The second reason that the court need not get to the substance is because it is totally unclear with respect what the relief actually means. What does an order mean that Parliament is directed to convene a proper and formal inquiry into this matter? Does it mean merely, as the Judge President sometimes seems to suggest, that Parliament must apply its own mind to whether misconduct has been committed? Or does it mean that, I say that Parliament, it's the National Assembly, or does it mean that the National Assembly must engage in a formal inquiry, i.e. some sort of trial, akin to the Judicial Conduct Tribunal? Or does it mean, as is sometimes suggested, merely a right to be heard? Well, we don't know, because Prayer 10 doesn't tell us. And courts cannot give orders that are unclear, and they cannot give orders that are incapable of being complied with. And with respect, if this court gave Prayer 10, the National Assembly would not know what to do, because it's unclear what a proper and formal inquiry even means in this context. And the Judge President, with respect, has vacillated on that score. So that's the second reason that the relief is unsustainable. But the third reason that the relief is unsustainable is that the relief is premature and is inconsistent with the decision of the Constitutional Court in Glenister versus the President. That's Glenister 1, not Glenister 2. Glenister 1 is 2009, volume 1 of the South African Law Reports, page 287, a decision of the Constitutional Court at paragraph 50. And in Glenister 1, what had happened was, this court will recall, there was a bill to disband the Scorpions. And Mr. Glenister had approached the Constitutional Court saying that it should declare that that bill was unconstitutional and intervene in the parliamentary process. And at paragraph 51, I do see that there's some disjuncture between the paragraphing on Safley and the paragraphing on the SA Law Reports. I'm giving you the paragraphing in the SA Law Reports. But paragraph 51 of the SA Law Report said, "It is not clear at this stage what Parliament will decide to do. The applicant's case regarding material and substantive harm is premised on the assumption that the legislation will be enacted without material change. However, Parliament may choose to make significant and substantial amendments, or it may choose not to enact the legislation at all. Until the content of the legislation has been determined by Parliament, the effect of the legislation cannot be determined." In other words, you cannot intervene before the parliamentary process is complete because one doesn't know what Parliament is going to do. And allied to that is paragraph 56, because in paragraph 56, there was an argument that the draft legislation itself posed a threat to the Constitution. And the court explained, the first difficulty with this argument is that it assumes that the content of the draft legislation will remain unchanged during its passage through Parliament. The court cannot make this assumption. I must proceed on the basis that Parliament will observe its constitutional duties rigorously. And it goes on to say, it would be institutionally inappropriate for this court to intervene in the process of lawmaking on the assumption that Parliament would not observe its constitutional obligations. Now exactly the same applies here. You are being asked to assume that Parliament or the National Assembly will not properly perform its constitutional obligations under 177(1)(b) on no basis at all in the supplementary affidavit, and then in the replying affidavit by taking out of context, unfairly out of context, the statement the Speaker made about the impermissibility of the relief. There is absolutely no basis to assume that the National Assembly doesn't intend to fulfill its constitutional mandate under 177(1)(b), and if it didn't fulfill that, then of course that would be open to being challenged in a court of law. But Glenister makes clear that it would be institutionally inappropriate, those are the words of Chief Justice Lange, for this court to intervene at this stage on the assumption that Parliament won't do the right thing. Of course, here we're not engaged in lawmaking, but the same process follows. Parliament is engaged in a constitutionally mandated process, and it is not open to this court to intervene at this stage on the basis of what is at most mere speculation or assumption. So for all of those reasons we submit, this court should simply say that no case has been made out for Prayer 10 and should avoid the difficult issues around what 177(1)b means and whether there is a right to be heard. And the court should do so because that issue might arise squarely in due course, depending on what transpires in this case, depending on what the National Assembly does. It might also arise in due course in other contexts, because I'm going to take the court in one moment to the parallels between 177 dealing with judges and 194 dealing with the public protector. And as you know, there are proceedings ongoing in relation to the public protector. And so if this court starts making, I say this with all due respect, bold and untethered pronouncements about what an inquiry to remove part office bearers involves, it may well have an effect on other cases, and the court would be doing so in circumstances where it's not necessary to decide, where no proper case is made out, and where with respect it would simply be inappropriate to do so. So in my submission, the court should stop there, and that should be the end. But let me address the 2 points which are raised by our learned friends for the sake of completeness. And these are then the second and third points in my address. The second is whether the National Assembly has to itself conduct an inquiry. And I address this with some caution because, as I have explained, it's entirely unclear what our learned friends mean by this. But let me make the point, which has not been answered by our learned friends and which is, in my submission, dispositive. If you have a look at 177 of the Constitution, 177(1), it prescribes a two-stage process for a judge to be removed from office. The Judicial Service Commission has to find that the judge suffers from an incapacity or is guilty of gross misconduct. And then the National Assembly calls for that judge to be removed by 2/3 of its majority, by a 2/3 majority. It's clear from that, in my submission, that the primary responsibility for conducting an inquiry in the sense of a hearing, a trial, etc., rests on the JSC, and as we know, in light of the statute, the Judicial Conduct Tribunal. The National Assembly then makes the decision whether to call for the judge to be removed. Contrast that, if you would, judges, with 194. It deals with the removal from office of Chapter 9 institutions. And 194(1), and I'll just focus on the Public Protector because she's the first one mentioned, the Public Protector, Auditor General, Commission, may only be removed from office on the ground of misconduct, incapacity, or incompetence. 194(1)b says a finding to that effect by a committee of the National Assembly, and 194(1)c says the adoption by the National Assembly of a resolution calling for that person's removal from office. So what's absolutely clear is that in 194, it is the National Assembly committee that has to make a finding about misconduct, and then the National Assembly itself decides whether to call for removal on the basis of that finding. Whereas in 177, when you're dealing with judges, it's the JSC that must make the finding of the misconduct, and the National Assembly makes the decision whether to remove it. Now, now what that suggests is that this attempt, which appears to be made to conflate these processes and say, well, really what the JSC said doesn't matter, and it's all up to the National Assembly, and the National Assembly can take the place of the JSC, which is the argument advanced in the supplementary papers, is plainly bad. We have demonstrated that in the heads of argument with reference to these sections. The heads of argument were filed in advance of our learned friends' heads, and they were unanswered on this point. There was no attempt to grapple with 177 and 194. When our learned friend addressed this issue or this prayer in chief, he didn't deal with it at all. And I collegially inquired whether he wished to make further submissions on prayer 10, and he said no, he stood by his heads. But so you get, with respect to difficulty, where our learned friends have just not grappled with the argument at all. And I submit that the contrast between 177 and 194 is palpable. Both of them have a finding of misconduct and a call for removal, but one of them reserves the finding of misconduct to the JSC, and one deals with the finding of misconduct at parliamentary level in the parliamentary committee. And the reason, with respect, is obvious. The reason is that the drafters of the Constitution took the view that a finding of misconduct against a judge was such a serious matter that it couldn't be left to a purely political process. It had to go to a JSC, which includes members of the National Assembly, but also includes members of the profession and academics and so on. And you will in fact know that most of the political office bearers do not even sit when the JSC makes its decision in relation to the removal of judges. And so the Constitution very carefully has adopted a stance which says that there will not be a political process in terms of determining whether a judge is guilty of misconduct. And in fact, that whereas with the public protector and others, rightly or wrongly, there is a more political process because it's the Committee of the National Assembly that determines it. Now, of course, that's perfectly permissible. That was the way the constitutional drafters did. And of course, the Committee of the National Assembly would act rigorously and so on. But my point is, you can't just ignore the constitutional structure by seeking to have the National Assembly take over the role of the JSC. So insofar as one can ascertain at all what the relief means about a proper inquiry by the National Assembly, insofar as it involves usurping the powers of the JSC, it is impermissible and would seek to push Parliament into a realm which is not its proper realm. And then lastly, there is the question, and this is the third point, about whether a judge has the right to be heard before Parliament makes its decision. Now, that is, sorry, I beg your pardon, before I come there, let me say, the only arguments that our learned friends put up on the basis of Parliament should have an inquiry, or the National Assembly should have an inquiry, are, can I say, analogous, or not even analogous, arguments resting on other provisions like the duty of cooperative governance or the duty of accountability, but there's no grappling at all with what the actual provision says and its contrast with 194. So there is no argument put up for that. Then when we come to this last point about whether a judge has the right to be heard by the Parliament before it makes its decision, our learned friends can rely there exclusively on Indian jurisprudence and one or two academic articles. But those are, with respect, unhelpful, because those constitutional and statutory provisions are not the same as ours. And so whether or not a judge in India has the right to be heard by the Indian Congress before it removes him is really neither here nor there. And the difficult issue that will arise, perhaps one day, is where a judge has been given a right to be heard twice, both by the Judicial Conduct Tribunal and by the JSC, does the judge have a right to be heard a third time by the National Assembly before there is removal? Now, I am not going to make submissions on that score because that is not an issue that is ripe for hearing. It is not an issue that is pleaded in the supplementary papers. It is not an issue that arises yet because Parliament has not taken, or the National Assembly has not taken any decision as to how it will deal with it. But I would say that insofar as the issue arises, it is by no means obvious that there is that right because of the prior two sets of hearings. But I do not make any submissions on that score because no doubt that the Speaker will have to consider that in due course, take appropriate advice, and the National Assembly will ultimately have to decide how it wishes to proceed. And it would be inappropriate and with great respect, unwise for this court to venture into that issue now when it is not a crisp issue that needs to be decided and when the matter is premature. And again, I would refer to the Glenister case in that regard. So in my respectful submission, the relief sought against the Speaker falls to be dismissed on all of those bases. I would emphasize that the flaws in this relief were pointed out in the supplementary affidavit, and at 010-9, paragraph 12, the Speaker pertinently invited the Judge President to promptly abandon Prayer 10 and said in that event no costs award would be sought, and then said if Prayer 10 is not promptly abandoned, costs would be sought. I respectfully submit that given that the Judge President elected not to abandon the relief and that is what required me and my junior to be here and the cost to be incurred, it would be appropriate for the Judge President to bear the costs of the Speaker, including the costs of two counsel.
Thank you, Mr. Butlander. Any questions?
Nothing from me. Thank you, AJP.
Nothing from me.
At the court, please.
Okay, thank you very much. Then it's time for the applicant, presented by Mr. Masuku, to reply. You can continue.
Thank you, Judge President, and thank you, Justices. In reply, I will deal with the submissions made by my learned friend for the JSC, Mr. Ngugaitobi, which seeks to impugn the motives of the Judge President in bringing this application. They were made by Mr. Ngugaitobi and Mr. Du Plessis. I'll address those which suggest that the bringing of this application was in itself an attempt to avoid accountability, as he puts it, to avoid the finding that the finding of constitutional misconduct. And I will also deal with the fact that there is a basis on which FUL should seek to invite the court to make adverse or harsh criticisms, as they use the word opprobrium or something like that, for the JP's reference to the 2009 JSC finding. And the fact that the JP essentially wants to hold the position he holds, continue performing his functions, at the same time dragging these proceedings through what they regard as an unnecessary process. Which submissions we regard as abusive of the Judge President by a party that has been given the privilege of being a respondent when no relief is sought against that party. And then I will also look at my learned friend's submissions in defense of the tribunal's stance that it sees its duty, its statutory duty, as vindicating the honor of the Constitutional Court judges, and therefore takes the so-called attacks on the Constitutional Court justices as a starting point for the analysis that is factored into whether or not there was gross judicial misconduct. And then I'll deal obviously with the premeditation issue, whether there was evidence in the tribunal on which to suggest that there was premeditation on the part of Judge President Hlophe. And I'll also deal with the argument that the presumptions do not apply, and they apply only when one is dealing with bias, and they do not apply when us analyzing whether or not there's been a judicial misconduct of the nature that we are engaged with. And then finally, I'll address the court on the submissions made on behalf of the speaker by my learned friend, Mr. Patlenda. Let me start with this big allegation that seeks to scandalize the Judge President's application by suggesting that it has been brought to paralyze the process for holding judges accountable and for holding him accountable in particular, and that this, as my learned friend for the JSC suggested, when he said he had listened very carefully to the submissions that had been made on behalf of the Judge President, and had come to the conclusion that the Judge President's application was really brought for selfish and self-serving reasons. That's a very serious allegation in the circumstances that we're involved in, because once again, it suggests that the judge president, is abusing the courts, and that has serious implications for how the court must see him, having been accused of, in fact, abusing the processes of the JSC, abusing the constitutional court judges, and basically lapsing in his judgments in relation to the conversations that he had with the judge president. It's an argument that cannot be left undone. Let me assure this court that this application is not brought for selfish reasons or for self-serving reasons. The judge president has served as a judge president for over 20 years. He has served with his colleagues, some of you, and is aware of the weighty responsibilities that are involved in the office of a judge president or in the office of a judge generally. To suggest that he would bring an application for the sole purpose of frustrating the completion of a constitutional process is in itself quite a serious allegation to make. And so it must look at what the motive of the judge president is in bringing the application. In essence, one has to look at the merits of the application, and one must see whether or not in the merits of the application it can be justified to hold the view that this is a meritless application whose sole reason to have been brought is to undermine the constitutional process by the Judicial Services Commission and by the National Assembly. The allegation is that he has manufactured a paralysis and wants to benefit from that paralysis in order to avoid being held accountable for the consequences of what my learned friend referred to as the gravest threat, internal threat to judicial independence, of which he has been found guilty of. He wants to be immunized from taking accountability. And that simple, and I mean, this was said as a matter of fact with the confidence that is astonishing if one looks at the facts, that the JP has no defense to the allegations against him. If one has read the record, that statement can never be made unless it is simply made to pollute the atmosphere for the decorum needed for adjudicating a matter that implicates the integrity of the office of a judge. To demonstrate the view that Judge President Hlophe is engaged in the subversion of a constitutional process, it is argued that he would request the disqualification of the JSC if the matter were referred back. And this is said in jest because it's said by a junior, but it's a serious thing for the judge president that he is cast in that light, that he's somebody who is constantly looking for technical points, as the FUL would suggest, and he would seize on those technical points and be unconcerned about whether or not his impeachment process has complied with the law, whether or not the inquiry into his conduct has complied with the law. And I go back to the presumption that even us as legal counsel for the judge president are obliged to extend that presumption of integrity and not impugn the motives of a judge who is fully aware of why the courts exist and in what circumstances he must bring an application before the judge, before the court. But let me address directly why this motive argument has no merit whatsoever. Obviously, firstly, it must be known that the JSC has lapsed in its constitutional obligation to deal with this matter in a way that protects judicial independence right from the beginning. And I say right from the beginning because the beginning was really when the JSC allowed the Constitutional Court judges to give evidence in the absence of Judge President Hlophe. They gave that evidence, they made that decision, which was subsequently set aside by a court because they breached elementary procedural fairness rights, which Judge President Hlophe had. The court told the JSC, go back and start afresh the process. What the JSC then did was to bring a committee of three. The committee of three listened to the evidence, did not allow cross-examination, finally brought a report 2009, which report was adopted by the majority of the JSC. We know that the 2009 JSC finding, which was favorable to Judge President Hlophe, was set aside. Hlophe was not involved in that. He is not the one who brought an application to have the 2009 favorable finding reviewed and set aside. Essentially, when the Premier of the Western Cape took the point that her absence from the JSC vitiated the entire JSC proceedings, the Judge President went to the court and said, no, but the Premier, on her own conduct, would have been disqualified anyway to sit in the JSC because he didn't hear that. He didn't take those submissions. And they said, well, the law says that the Premier must be there. If she's not there, that's the end of the matter. The Judge President said, okay, fine, but let's look at the composition. It must be the majority of members who are present in the JSC. The court said no, majority means the majority. 13 members ought to be there where the matter involves a provincial, where the matter is a provincial matter. Then, of course, the Premier and the representative of the Judge President ought to be present. Thereafter, the SCA has two judgments in which they criticize the JSC. And they criticize the JSC for failing to uphold a standard of proceeding that would have ended this unhappy episode in 2009. So the court set aside those proceedings. The matter then comes to a head because what the JSC then does, or what Parliament does, is to create a new law, the JSC Act with its amendments, in which a new procedure for dealing with judicial misconduct cases was set out. So the Judge President is taken through this new procedure. He goes through the Judicial Conduct Committee, which finds that the matter must be referred to the Judicial Conduct Tribunal, and which also finds that the tribunal then obviously recommends to the JSC what the position should be. Now, what happens there is that with the new legislation, Justice Ngabinde and Justice Jafta take a constitutional point and they litigate the constitutional point to the Constitutional Court. We all know, and I'm going to refer to this aspect because it's very important. When the matter gets to the Constitutional Court, it is not entertained on the merits. And this is very important in how the court should interpret the submissions made on behalf of Judge President Hlophe, which are that the Constitutional Court judges ought to have believed their colleagues when they said, we've dealt with this matter. We dealt with it sufficiently. There is no need for the entire court to have been involved in this particular complaint, because what then happens is that particular complaint, which became the complaint of all the judges of the Constitutional Court, meant that the Constitutional Court, although it has the ultimate jurisdiction over constitutional matters, would not sit and decide whether or not the constitutional challenge was sound. So its jurisdiction was obviously taken away because of the fact that the judges were complainants in that particular matter. Judge Hlophe is not involved in that. The matter comes back to the JSC. after the dismissal of the application by Justice Nkabinde and Justice Chapter. There is a issue relating to a judge who had been appointed to be the third member of the tribunal, which Judge President Hlophe deals with. That issue happily is resolved, and another judge is appointed. Supreme Court of Appeal judge is appointed. The matter is ready for running. And at the right time, the matter runs, which was December 2009. Sorry, 2020. In the proceedings, Judge President Hlophe can never be criticized for having been unkind to his colleagues. He can never be described as having been obstructive in the way he gave the evidence. He was candid, he was clear, and the tribunal found no basis to make adverse credibility findings so far as his evidence was obtained. He did not change a thing in relation to the evidence he had given previously to the JSC in its different formations. We are here today because the JSC, having considered the matter, failed to apply its mind to a jurisdictional question relating to its composition, a matter that had arisen in 2009. So given the two judgments that had dealt with composition, one would have expected that the JSC would have paid attention to what its composition would look like. And the fact that the JSC doesn't do so also answers the question my learned friend for the JSC raised and tries to blame Hlophe for, Judge President Hlophe, for causing what he says is a paralysis in the system, for causing problems in the system of holding judicial officers to account. And then, of course, if we succeed, if the court succeeds, if the court holds any of the jurisdictional challenges that we've raised, we're back where the JSC was in 2009. And my learned friend made what I would regard as a very shocking submission when asked to deal with the issue of whether to be competent for the court to remit the matter. His answer was to do so would be to paralyze the JSC, and would also be to reward Judge President Hlophe, because then he doesn't get held to be accountable. Now, if there's any doubt about the importance of making a declaratory order against the JSC, it is that particular submission, which suggests that the JSC is paralyzed from performing its constitutional functions. If the JSC is paralyzed, it is not paralyzed because of Judge President Hlophe. It is paralyzed because it simply did not pay attention to what it should, to the law. It did not pay attention to elementary requirements involving the composition of the JSC. If it had paid attention to that, we would not be here in court seeking to have an order to set aside the JSC findings. Now, there's an accusation leveled against Hlophe by the FUL, but those accusations about FUL are now normal for Judge President Hlophe. They are made in public, they are now made in court. So I won't even give oxygen to those criticisms by FUL, but serve to say this particular submission. Judge President Hlophe, one has to be fair, one has to be decent about it, has done absolutely nothing wrong insofar as bringing this litigation to this court is concerned. Should not be criticized for it. But the suggestion that it takes technical points is a very irresponsible submission coming from the FUL, who in 2009, with themselves took the similar points about procedure that the JSC had adopted, failure to cross-examine. They took that point. They succeeded in it. Judge President Hlophe can't take procedural objections, which are themselves very important for the substantive outcomes of the JSC. The credibility of the outcomes of the JSC depend on how the JSC has complied with its own procedural rules. Let me address this issue raised, conveyed to the court by Mr. Ngogaitobi on behalf of his junior, which is that Judge Hlophe, if the remittal is done, Judge Hlophe would ask for the recusal of everybody. That's such an unfair submission. If one pays attention to what has happened, Judge President Hlophe was in the Constitutional Court 2011, asking the entire Constitutional Court to hear the matter on the basis of necessity. He said, I accept that you are conflicted in one way or another, but there's a doctrine in administrative law that if you are the only people who can give me justice, please give me justice even if you're conflicted. There were extensive heads of arguments and submissions made on that doctrine of necessity. The Constitutional Court said in response, in order to protect the integrity of the processes of the Constitutional Court, they will not hear him. So to suggest that he will take a recusal point whenever it suits him is also a submission that is not borne out by the facts. Judge President, and you would have seen that I tried my best to avoid saying anything about Judge President Mlambo in my address. And I won't take the issue of Judge President Mlambo further than I am making the submission. Judge President Mlambo makes the submission, writes to the JSC and says, look, I was involved in two matters. The first matter is the matter which was the subject of the discussion between Judge President Hlophe and Justice Nkabinde and Justice Jafta. I was also involved, so he says, in the judgment which was brought to the Supreme Court of Appeal by the JSC, challenging a favorable outcome on Judge President of Judge President Hlophe's application to have certain declaratory orders in relation to how the Constitutional Court judges had affected the conduct of the Constitutional Court justices had affected his constitutional rights. When Judge President Hlophe had the option of vigorously saying, Judge Mlambo, you are conflicted because of those points, Judge President Hlophe left it to him. He said to Judge President Mlambo, I extend the presumption of judicial independence to every judicial officer. You make up your mind about whether or not, on the facts that you know, you are in fact conflicted. And he was correct because he referred to the Code of Conduct, Article 13, which says a judge must recuse him or herself from a case if there is a real or reasonable perceived conflict of interest, a reasonable suspicion of bias based upon objective facts, and shall not recuse him or herself on insubstantial grounds. Obviously, the current position is that Judge President Hlophe says, well, look, I mean, when I read the report, I mean, the transcript of the discussions, it simply says that you don't consider yourself to be conflicted, but I have other facts, and I don't want to go into discussing those facts because in a way, what that would do is place this very court in an invidious position. And I understand the court takes the view that you're not minions of Judge President Mlambo. But the point of the matter is, at some point, the system has to work. And that is why Judge President Hlophe, even though he's minded to raise these issues of conflict, leaves them. He has not raised the issue of conflict in relation to this particular bench. He has not asked this to consider it. Even though his own experience as over 20 years of being a judge president, he says every time a matter comes to his court as a judge president for the past 20 years involving a judge in that particular court, what he does is he invites other judges from other divisions. That's a principle that he works on. But he understands that is not a principle that applies everywhere. So this court doesn't operate at that level of principle. And he accepts that judges take an oath of office to be impartial, and so when he takes a point of recusal, he takes it having considered what exactly the evidence is in relation to that particular point. So to suggest that Judge President Hlophe would simply raise a recusal a point if the matter is remitted to the JSC is to try and portray him as an irresponsible judicial officer who does not want to be held to account by the JSC. And this is why the argument on motives is an irresponsible argument, because it is simply made in order to portray a judicial officer who is trusted by the community of the Western Cape, who is a colleague of these justices that are hearing the matter, that he has only come to this court to abuse the power and the time that this court has. It is wrong to make those kind of submissions, and we would say that the court does not accept the invitation to make any adverse remarks in relation to those particular to suggest that Hlophe has brought this application simply to abuse it. Even if the court were to find against him, there is absolutely no basis for the ad hominem approach adopted by the Judicial Service Commission itself. Because here is the problem. The paralysis is caused exactly by the submissions that are made by the JSC to this court. It tells you that it's going to be paralyzed. It says it leaves this court with absolutely no option, and yet it is the constitutional body solely responsible for determining whether or not a judge is misconducted himself or herself. And to suggest that this application has been brought in order to paralyze that process is wrong. In fact, it's been brought in order to enrich the process. From this process, there are potential cases that will come to the JSC, and the JSC must look and do a proper audit of whether or not its processes are in fact consistent with its supreme responsibility of dealing with judicial misconduct complaints. So we would say, for all those reasons, we submit that it's just, this case is simply about whether or not the JSC was properly composed. And on those submissions, I couldn't understand the jurisprudence that our learned friend for the JSC is suggesting should be adopted by this court. This court is bound by the two judgments that we referred to in our address. And I say no more than to suggest to say that this court should disregard the involvement of a person with no constitutional status in a constitutional process involving the protection of judicial independence, which is intended to advance the public interests, or rather the public trust in the judicial institution. I say that submission is just wrong, that this court must disregard that for a convenient interpretation that is inconsistent with what the judgments of the Supreme Court of Appeal have said. There is the argument of necessity my learned friend tries to raise would have applied in relation to the president and the deputy president of the Supreme Court of Appeal, and not to Justice Mba. The doctrine of necessity, the doctrine of pragmatism, would have applied only in relation to those two. President Maya and President Pete, Deputy President Pete, would have been entitled by virtue of looking at the Constitution. They are the functionaries that are nominated, that are assigned to perform this constitutional responsibility. If they came up to the JSC and they said, look, on the doctrine of necessity, I'm the only president, I'm the only person who can in fact sit in this JSC, even though I'm conflicted I am the only person who can sit and hear this matter involving the judge president. Declares her conflict with the JSC, and the JSC collectively engages with it and decides whether or not it is appropriate for her to continue sitting or it is not appropriate for her to continue sitting in the matter. It cannot just be the fact that she decides on her own that she is conflicted and walks away from it, and then performs something that my learned friend can find no legal authority for. President Maya, or the president of the Supreme Court of Appeal, and the deputy president of the Supreme Court of Appeal do not have appointing powers. They do not have assignment powers. They cannot assign somebody else to the position of president. And this also, it can be explained. I mean, I say no more than just that proposition is right. But this is also another sign of confusion that is characterized or lapses, serious lapses by the JSC. That at some point, when they think that they need a chairperson of the tribunal, or sort of the JSC, they go to the president and they say, President, appoint this person so that they come and chair for a day the JSC process. But when it comes to Justice Myers, to the president of the Supreme Court of Appeal and to the deputy president of the Supreme Court of Appeal, there is no appointing. They don't adopt the same attitude that perhaps the minister should appoint for a day a president to come and act in the JSC. It just shows you that there is great confusion in the JSC. The lapses in this institution on this matter are there for the record. This is not a characterization of the JSC that is unfair or that is hysterical. It is not. It is borne out by the facts themselves, and we say that to suggest that a non-constitutional member of the JSC should be the one that sits and presides over the JSC, that sits as a member of the JSC to adjudicate to be a part of the adjudicators of a constitutional process like that is just plainly wrong.
Mr. Masuku, can I interrupt you to ask a question?
Yes, Judge, thank you.
On the question of your proposition that neither the president nor the deputy president of the SCA have appointing powers, did I understand you to say that an appropriate way to overcome the paralysis problem would have been for the president to have nominated another member of the SCA to sit in their place?
No.
The proposition.
No, it is not the proposition. I'm just trying to show the absurdity of the actual appointment of Judge Kampembe by suggesting that the JSC adopts a different methods of trying to cure its own problems. In one moment, they try and invoke the president's powers to ensure that there's a chairperson of the JSC. When it involves another person, they don't do anything like that. All that they do is simply to suggest that functionary or that person in the person of the president or the deputy president has got powers of assignment or powers of appointment. And with respect, we say, I just raised that really as a way of it's an attack on the rather than a validation of the proposition.
Yes, right. I understand that your principal proposition is that the president and the deputy president of the SCA couldn't appoint Judge Umba. But what is your submission about how the problem of the absence of both of those office holders can be solved?
Yes.
If what they did was wrong, if we assume that for the purposes of the analysis, what must happen? There seem to be a couple of obvious permutations. One, no one comes to the JSC, which threatens its quorum. B, the President of the Republic appoints somebody to serve in their stead on the basis that they are either not available or absent, and that's a separate debate. Or C, what's left?
Thank you, Judge Sutherland. The proposition that we make is that the Constitution is very clear about who should sit in those. That's the starting point. Who should sit in the JSC when it considers a judicial misconduct complaint. Those members could sit simply on the doctrine of necessity. They could sit. They could go to the JSC and say, well, look, I'm the assigned functionary. The Constitution says only this. It doesn't give me an appointing power. It doesn't say I can nominate somebody. Where there is an alternate, obviously, the person conflicted, if they are conflicted, the alternate, if it's not conflicted, would then stand in. But the doctrine of necessity is an often ignored doctrine that is designed to resolve these kind of complex questions. And people in the position of Judge President Hlophe would have understood that the only people who can give him the hearing are the people that are nominated in the Constitution, that are assigned by the Constitution to give him a hearing. So we say, essentially, don't try and resolve it by going to the president and inviting the executive to appoint a member to this body by simply appointing them for a day. Don't even, the option of no one comes to the JSC is itself problematic. Because as you would recall, the SCA says it is only when it's legally impossible for somebody to be there. And we haven't explored what legal impossibility means, because recusal is a legal impossibility, I would assume. But the point that we're trying to say, what would obviate the problem? And this is the problem that we have with the fact that the matter that we brought to the Constitutional Court never decided the point. But we're asking you to look at it and to decide whether or not we are correct. If there is a necessity point to be debated, it is not a necessity point in terms of which Judge Mba could be appointed, or the president could invoke powers she doesn't have, or he doesn't, the deputy president he doesn't have, to appoint somebody to the position. If that appointing power was there, or could be implied anywhere in the Constitution, it would have been there. But for the president herself, or the deputy president, to say, yes, I am I'm mentioned in the Constitution as the functionary that must sit. And so on the doctrine of necessity, if it's necessary for us to sit, even though conflicted, I will sit. And Judge President Hlophe argued vigorously for that proposition and referred to extensive literature on on the precise circumstances in which that doctrine has been invoked, where the final decision maker is the final decision maker, there is nobody else. And then the doctrine of necessity says, well, I mean, even though I'm conflicted, man, I'm the only person who can give you this hearing. So I appreciate my conflict, and this is where the presumption of judicial independence and the presumption of judicial integrity comes in. Because one would say, well, you know, a judge who has recognized the conflict is expected by the community when they perform those functions in the JSC to resort to to rely on those attributes of impartiality and fairness, recognizing their own conflict, but to deal with it on the basis that it is simply a constitutional necessity for her to sit and to adjudicate the matter.
Well, look, that obviously is one option. Let's consider this. When the Constitutional Court was faced with that same dilemma, they decided that because they were compromised, they couldn't hear it. And they had the advantage in that circumstance that a lower court, the SCA, had decided it, and they concluded that the lower entity's decision would have to stand. Now, it seems to me that one of the things to take away from that example is that in other instances where the dilemma arises, the office bearer would then decline to sit for the same reasons that the Constitutional Court declined to sit in that matter. Now, in that scenario, what would the president and the deputy president of the SCA have had to consider as their options? The president had an easy passage. She decided she was conflicted, and therefore it fell to the deputy president. But now the deputy president is faced with that dilemma, the same dilemma that the Constitutional Court had. He says, I'm conflicted. If I apply my mind to the doctrine of necessity, I have the example of the Constitutional Court, which says I shouldn't participate. If nothing more can be done to arrange a substitute, and the consequence is that the JSE is paralyzed, what does that mean? Does that mean that the JSE, thus paralyzed, must simply defer to the Judicial Conduct Tribunal and say, we are not in a position to form a quorum in order to deal with the Judicial Service Commission Tribunal, its decision will have to stand? Is that an option?
With respect, the example you've just given, Judge Sutherland, highlights the problem. It highlights the problem significantly. And what this court has is probably an opportunity to say something about the doctrine of necessity and where it is appropriate to apply it. The Constitutional Court did not close the door for that kind of argument to be made, because let's have a look at what the implications of the Constitutional Court's judgment, because it simply said we are protecting the integrity of our own discomfort with sitting, the integrity of our own processes by refusing to sit in the case. But in its analysis, to my recollection, and I use recollection because I was involved in the case and I argued the doctrine of necessity, I do not recall that the court actually made a pronouncement on whether or not the doctrine of necessity could assist. It does say somewhere in one of its paragraphs that we were invited to hear the matter on a doctrine of necessity, and then it says, well, but we find that we are so conflicted that, you know, the integrity of our own process would be questionable. The point I'm raising, Justice Sutherland, is that the rule of law and the principle of legality cannot give way to convenience. The public confidence would not be weakened if a functionary says, look, I am the only person who can do this. The Constitution demands only me to do it. And the problem with the Constitutional Court, with respect, is that where they are now, or where they were then, highlighted the problem, another different problem of having brought themselves into the ambit of the conflict, of the actual conflict itself.
Mr. Masuku, maybe just to clear my mind, or do you still want to respond on this aspect?
No. I think I'm trying to, but I'm not sure whether I have tried my best. It's a difficult proposition.
Just assist me here. Did the JSC itself discuss about the paralysis that would be caused if the president and the deputy president are not there? Or did they just accept Justice Mba when he was referred to by either the president or the deputy president or both?
My lord, that's a very
mind on this issue of the appearance of Judge Mba.
Justice Ledwaba, that's a very important question, because the answer to that question is you will find nowhere in the record where the JSC grappled with the question of paralysis. You'll find it nowhere. Only time they discuss the issue of recusal is in the context of Ms. Tsepe's request to be recused, and in the context of Judge Mlambo's responding to the own questions about whether or not he could recuse himself. There is nowhere in the record. And this is why sometimes, I mean, look, obviously I don't mean to be nasty, but if you look at the heads of arguments on behalf of the JSC, in paragraph 100.2 of the head of the JSC, the procedure of the JSC was determined by the JSC. The replacement of President Maya and Deputy President Betse by Judge Mba was not regarded as being of any adverse consequence. Hence, the meeting proceeded without any objection from any member. You'll find it nowhere in the record.
It's 1:15. I'm going to propose that we adjourn for 15 minutes, and I will take the matter forward at 11:30.
Thank you, Judge.
Thank you.
I think there's still a minute to go. Our respective clocks aren't synchronized. Acting
You know,
JP.
I was just talking to my secretary now that the time on my cell phone and on my laptop,
Yes,
they don't tally.
yes.
Okay. No, thank you. Advocate Masuku, you've addressed us for about 45 minutes, meaning that you've got about 1 hour, 15 minutes.
Judge President, I'm sure that you will have mercy should I request a further indulgence, but I don't want to stretch judicial patience.
No, it's just a reminder, because sometimes as you would be, articulating your arguments, you may lose the sense of time. But I always have mercy. I wanted to give you an hour and I give you 2 hours.
No, thank you.
You may proceed.
Thank you, Judge President. So just to come back to the questions that I was asked by Justice Sutherland and yourself, JP, the arbitrariness of the JSC process is in fact highlighted in exactly the example that Judge Sutherland raised. If the approach taken was that, well, we're paralyzed at the JSC, so the tribunal must be the final word, we have made submissions about why the tribunal has no power to make findings of gross judicial misconduct. They are not a constitutional body under Section 177(1)(a) to make those findings, so it would be incompetent for that kind of arrangement to be made. But the arbitrariness of it is in that there is nowhere in the record where the JSC engages the question of its composition. In fact, at some point when we suggest that a timesheet with all the names of the people that are there, roll call, if you want to call it that way, could have assisted, they deride that suggestion, and they tell us, well, that's not how they do things. But the JSC has been absolutely sloppy in the way they've dealt with this particular complaint.
Mr. Masuku, can I ask you, if they had debated the doctrine of necessity at that meeting and it was on the record, would that have sufficed?
At least thank you, Justice Victor. What would have helped is that anybody looking at the record of the JSC would have seen the rationale, and my learned friend Ngoetobe raised the issue of good reason. They would have seen the rationale behind the ultimate composition that comes up from the JSC. They would have at least appreciated that the JSC had engaged with difficult questions relating to, or they were in fact aware of the difficult questions that they needed to address, and they in fact took time to address them very pointedly on the record. For anybody wishing to know how the JSC has come to the conclusions they have come to in terms of the composition of the JSC, what process was followed to come to that point.
But so, the facts would have spoken for themselves, because we know that the president and the deputy president of the SCA could not sit.
No, that's where.
I think you've made the point that there's no power of delegation, or for them to suggest someone else sits. I've noted that.
Yes. No. Yes, I have made the point that they don't have appointing or delegation powers. They should not delegate another member. In fact, that process itself is not in the record. We know for the first time in the record that how Justice Mba was appointed. We know that for the first time in the answering affidavit. It's not in the record. Nowhere in the record. In the Rule 53 record.
Right, thank you.
Justices, I just want to address an issue of, I consider the issue relating to the allegation that made by, again, FUL, and also submitted by the judges of the Constitutional Court in relation to the appropriateness of the JSC upholding the ruling by, or the finding by the Judicial Conduct Tribunal, that it saw its responsibility as to vindicate the honor of the justices of the Constitutional Court for the manner in which Judge President had conducted himself. Again, the idea of wanting to portray Judge President Hlophe as a judicial misfit by the FUL is patently clear. In 2012, and you'll find that justices on page 006144 of the record. FUL brought a complaint to the JSC, essentially asking the JSC, complaining about the manner in which Judge President Hlophe had defended himself. They said that the manner in which he had done that was gross judicial misconduct. The ruling of the Judicial Conduct Committee was to dismiss that complaint. That's the first point. It's not open for the justices of the Constitutional Court, the ones that are complaining, to resurrect that complaint without a formal complaint before the JSC. Because, as you would have seen,
on that point that you are making, I recall one of the counsel arguing that this was entertained because Judge President Hlophe raised this as a defense.
No. That's incorrect. That's incorrect. It was raised as a standalone point. It was no context whatsoever. There was no entry point, the basis on which it would justify the resurrection of the allegations that Judge President Hlophe misconducted himself when in defending himself. That question you'll see in that ruling of 3 judges, 2 JPs and a judge of the High Court, dismissed the complaint that there was no basis, that there was a basis. They did say that the manner in which he had defended himself raised concerns. In fact, they said it could actually amount to gross judicial misconduct. But they said, in dismissing it, they said, well, there was an explanation given by Judge President Hlophe for why he defended himself the way he did. And it says that it's important, that's in paragraph 18.3, it is important to mention that the Concord judges subsequently gave an explanation for that showed that the suspicion that motivated the respondent's response and accusations were unfounded. He accepted the explanation. For that reason, his counter-complaint was dismissed. What has happened here is that it's smuggled through the tribunal report as an aggravation, and the JSC as well. At the JSC findings, you'll see that the manner in which he conducted himself is brought in as an aggravation. But it's just irregular for them to have done that way. If the tribunal wanted to expand the complaint against Judge President Hlophe, they should have done so. Then would have dealt with it there. So essentially, he was not given a hearing on the allegation that the manner in which he conducted himself was inappropriate. He was not in cross-examination. I do not recall, and I could be wrong. I don't recall that that was explored as a complaint by the judges of the Constitutional Court. I recall the submission made by my learned friend, Mr. Marcus, to the tribunal, where he invited and implored them to vindicate the honor, to use his words, to vindicate the honor of the justices of the Constitutional Court, whose reputation, as he put it, and dignity had been violated by Judge President Hlophe. That was simply not open to the tribunal to do so in terms of its in terms of the scope of the complaint that they were supposed to investigate and make recommendations on. It was not open for them to go that route. And with respect, if they were opening that route, they were obliged to give Judge President Hlophe a hearing on it.
Aren't we confusing two separate things? The allegations were made of bad faith. It's true, it was the subject of a complaint which was dismissed. But having been dismissed, there has not been a formal withdrawal, so the argument runs, of the allegations, nor has there been an apology. And what furthermore it's contended is that the insinuation of bad faith was persisted with. Isn't that the context in which, outside of a complaint about bad faith, that the tribunal took it into account?
Yes, I thank you, Justice Sutherland. The problem is that the matter, once dealt with by the three judges in the committee, and having dismissed it and given a full explanation that of the circumstances under which these allegations were dealt with, it was no longer, they didn't ask Judge President Hlophe to apologize. They didn't direct him to apologize. There was no complaint by the Constitutional Court judges for him to answer before the tribunal, and to try and persistently draw Judge President Hlophe's complaint and the manner in which he defended himself against the Constitutional Court judges is just not part of the complaint against him. The complaint against him, which was supposed to be investigated, was in the four corners of the complaint of the justices of the Constitutional Court. It did not include how he defended himself. That issue, the FUL tried to bring, it was dismissed. And because Judge President Hlophe was not asked to apologize or to reflect on those remarks, there was no basis on which it should be competent for the tribunal to have simply adopted that kind of attitude without having given him a hearing. At the very least, we would have expected the tribunal or the JSC to say, we are minded to go back to that issue and to particularly go back to it as an aggravation of your conduct. What submissions can you make on that particular question? Even though it's incompetent to submit, at least there is a veneer of justice or fairness by giving him a right to reply to that particular question. If they'd done that, perhaps Judge President Hlophe would have simply tendered an apology and said, well, I mean, to the extent that the justices of the Constitutional Court are still unhappy about the JSC ruling, the committee ruling on the very question, and they want an apology from him, then they must put it in a way that Judge President Hlophe can answer the allegation. But it just can't be correct to smuggle it in the way it's been smuggled in. This is the paralysis that we're talking about, where the nature of the complaint is very contained. But what the tribunal and the JSC does is they inflate the whole thing, and they bring issues that are not relevant for the determination of the complaint.
How would you suggest that we distinguish the Edling decision from these circumstances? That's the advocate who was struck off the roll for misconduct and who had accused his accusers of bad faith. As best I recall, he wasn't invited to apologize either. How do we distinguish that case from this circumstance?
With respect, I've not engaged with the facts. I can't make the submissions I'm asked to make based on that judgment. I would have to read it in order to appreciate the answer I give to Judge Sutherland. But the submission.
Thank you.
Yeah, maybe on this aspect, just to clear it further, it was Advocate Gilbert when he argued about the attacks on the CC judges. He strongly submitted that Judge President Hlophe persisted with the attacks on the Constitutional Court judges, and even at the JSC, when he made his representations, he persisted with these attacks. Hence, they had to raise this aspect in their reasons why they say there was gross misconduct.
Yes, I recall that. But can I then just address that question in the following manner? Right at the beginning of the of my learned friend Mr. Gilbert Marcus for the justices of the Constitutional Court in the tribunal itself, this is what he said. You will find that if you bear with me, you'll find that on case line pages 008 4238. And then you'll also find it 008 4239. He said the entire complaint is dependent on the first-hand evidence of Justices Jafta and Kabinde. And then in 4239, at line 3, he says, I would wish to address you in advance of that to explain why in our respectful submission, their presence is not required precisely because they are dependent entirely on what they were told by Justice Jafta and Kabinde. If Justice Jafta and Kabinde cannot sustain the complaint, then everything that was conveyed to my clients of necessity is hearsay, and they cannot contribute anything to what transpired between Judge President and Justice Jafta and Kabinde respectively. And then if you look at 008 4242 in line 17, he says, my concern is that they, meaning the Constitutional Court judges, by definition cannot give first-hand evidence of what transpired between the JP and Justices Jafta and Kabinde, and therefore their evidence by definition is irrelevant. It has nothing to do with admissibility. I raise that to suggest, to make the following submission. The Judge President Hlophe is entitled to raise a defense to allegations of judicial impropriety. He is entitled to confront his accusers on those allegations. When the justices of the Constitutional Court took the view that whatever they had to say about this matter depended entirely on the two justices, they were correct. In fact, it went further, that whatever they had to say about the matter was hearsay. Judge President Hlophe then must sit and say, okay, now I've been exposed to a very difficult judicial environment by judges who take the view that their evidence is hearsay in the absence of the two justices that were involved in the conversation. They had nothing to add. The entire complaint was dependent on the two justices. The two justices have come to the tribunal. They say, no, the statement of the Constitutional Court is incorrect. Doesn't correctly reflect what we told them or what we wanted to say to them. Judge President Hlophe did not persuade us. He didn't tell us how to handle the evidence. He said what he said. So I'm just saying, always be mindful that this situation was the gravest situation ever to face a judge, a South African judge. And I'm not saying that the judges of the Constitutional Court were not similarly faced with what they regarded as grave. We know that what they regarded as grave, the two justices did not individually believe a complaint was justified. So what I'm saying is, when you look at how Judge President Hlophe defended himself, do not lightly take the allegation that he insulted them. Look at the full defense and see whether or not a reasonable person in his position was not entitled to have mounted the defense that he did. But it's not an issue that the JSC should have dealt with. It's not an issue that the tribunal should have dealt with, especially without giving Judge President Hlophe a hearing. And the submission by my learned friend that Judge President Hlophe has persisted with attacking the justice of the Constitutional Court is simply is devoid of any truth. It's not truthful to say that. To say that the judges, the two justices, Justice Nkabinde and Justice Jafta, were reluctant judges is not an insult, because you will see and find in the record the reluctance of Justice Jafta, who says, this guy is my friend. I didn't think it was desirable for judges to be exposed to cross-examination. You will see that Justice Jafta and Justice Nkabinde, they write a document which is published in which they clearly point out that they don't intend to complain. They are not complainants. Of course, they explain it. They say, well, with the benefit of having heard what others think, we became a part of collective complaint. But you'll also appreciate that in these proceedings before the JSC and the tribunal, before the tribunal, they made it absolutely clear that they were not getting involved in how to characterize Judge President Hlophe's conduct. And I made the submission that as judges of the Constitutional Court, with weighty responsibilities, they were obliged to have taken a view on whether they regarded the conduct that they were faced with as conduct warranting the removal of Judge President Hlophe from his office. And I dare say, if you look at what they said and the submissions made on their behalf, it was clear they stayed away from from making those submissions. But the bottom line that I'm making is that this is a moment for whoever handles this case going forward, particularly this court and subsequent courts, to try and put some decorum in how this matter is dealt with and handled. There is great antipathy towards Judge President Hlophe. I appreciate that. But I mean, the courts will know that when we were before this court, we were in a safe space, because we know that the judges are not going to be moved by the fact that the people that are involved are persons of esteemed judicial office. They will apply the law. And I didn't know the word minion until Judge Sutherland mentioned it to my learned junior. But they will know that judges take their oath of office very seriously. And they will not likely impute ill motives to Judge President Hlophe for the manner in which he characterized his own defenses. If one reads the record, can never escape the submission that there is a legitimate basis to suggest that Justice Nkabinde and Jafta were fairly uncomfortable with the position that they ultimately found themselves in. And they were uncomfortable for a number of reasons. They believed they dealt with the issue, and they managed to deal with it and finalize it. That's how they characterized it. At the tribunal in December 2020, it was made clear to the tribunal that Justice Jafta and Justice Nkabinde felt they had dealt with the issue. And Justice Ledwaba, I think you've muted yourself.
We can't hear you. We couldn't hear your submissions for about a minute, in the last minute. And there's a signal on my laptop that there's bad network quality. I don't know if the other colleagues could hear. Did you hear the submissions that he made in the last 30 seconds or so?
Yes, I have.
All I just said, Judge President Ledwaba, is that there is a need for the courts to really start dealing with this matter in a way that restores the confidence of the public. Let's not just be moved by the fact that by what the FUL wants to happen, which is Judge President Hlophe must just leave the bench. He must leave. He has a duty for which he was appointed. And until the right processes are completed, no party before this tribunal before this court should make the submission that the FUL made, which is that he should leave. He's not offering to leave. What would satisfy the FUL is that Judge President Hlophe should announce tomorrow that he's resigning then there will be peace in the valley. We have to grapple with these difficult constitutional problems. And Judge President Hlophe is going to be a constitutional guinea pig for trying to strengthen the adjudicative processes that must be engaged with in order to ensure that judges do not go through incompetent processes that they've gone through to get to where we are now. And so I'm saying this. Justices can't see, but I am kneeling on the ground and with a tear in my eye, asking the judges to move away from the emotion of this case and to just look at the cold law and be moved only by one thing.
We're gonna be cool and approach this matter impartially and not allow emotions to.
I'm responding to the responses of my learned friends who, in very, very stark terms, were inviting this court to listen to the view that Judge Hlophe must move, must leave. And I'm saying, okay, if FUL has got the platform in public and here in this court to say those things, but be moved by the protection of judicial independence. That protection can only be done through the rule of law, through the proper application of procedural and substantive fairness. And it's time to get, and when my learned friend says it's time for politicians to get involved, here's the problem with that kind of submission. We're starting from the allegation that there's a paralysis. So politicians must get involved in protecting judicial independence. Of course, they have a duty to protect judicial independence. But to suggest that the Judicial Services Commission, with its weighty constitutional obligation to do so, must just be left with an unconstitutional process is just a far-reaching submission to be made. We want a finding of a JSC that is lawful, that complies with the law, that anybody looks, generations to come, will look at this finding and say, justice was done and judicial independence was protected. The independence of the judicial office and the integrity of the judicial office was protected. When Parliament looks at it, the National Assembly looks at it, they ought to be guided by the rigorous adherence to the rule of law that this quasi-judicial body has a responsibility to fulfill. So I'm making this submission because I'm trying to get us to get out of this paralysis of believing that there's nothing else. We can't serve this thing. We can, because the law has given us the resources and the principles to resolve it. If the JSC simply pays attention to what it ought to do in terms of procedure and substance, then we will not be in this quagmire. They simply didn't pay attention to their duties. So we shouldn't be told, and this court should not accept that submission, that forget legality, go for convenience, go for pragmatism, let the politicians deal with it. And by the way, I mean, Judge President Hlophe has made a submission, and I'm going to go to that, and said, okay, I mean, if you send me to Parliament, or to National Assembly, I will go. In fact, I want a hearing in Parliament. I want a full hearing because I do want to make submissions about how I've been treated. We are told, well, you know, that's not the job of Parliament. But I'll get to that submission. All I'm saying is that there shouldn't be judicial fatigue around resolving this question, because FUL and JSC take the view that Hlophe has got motives of paralyzing these constitutional institutions. Far from it. We shouldn't get to that point where we feel paralyzed. But for that submission to be made on behalf of the JSC is very telling of where the JSC is in terms of its appreciation of its role as a constitutional guardian of judicial independence. Let me make the submission on the on the allegation that the presumption is not applicable, the presumption in favor of judicial independence is not applicable, which my learned friend, Mr. Marcus, submitted. The first submission in that respect is that it is applicable because Article 13 of the Code of Conduct deals with recusal and places on the judge a mandatory obligation of recusal if there is a reasonable or real or reasonable perception of conflict of interest or a reasonable suspicion of bias based on objective facts, and shall not recuse himself or herself on insubstantial grounds. All of this confirms that what the justices in many cases, but I will refer quickly to the Dilase judgment, the judgment of Justice Museneke, where the Honorable Justice described what the allegation of bias actually means. And you remember that in the Dilase case, there had been a complaint that of bias, and in paragraph 4 of the Dilase case versus South African Post Office 2011, volume 9, BCLR 905, the Constitutional Court. In paragraph 4 of that case, it says their founding deposition levels grave accusations against the Supreme Court of Appeal. They name its judgment a gross miscarriage of justice and attribute actual bias to the court. They charge the judgment that the judgment has not been delivered impartially and without fear, favor, or prejudice, inasmuch as it was specifically designed to favor the post office and prejudice the applicant. I mean, then paragraph 5, they say they accuse the court and Judge Nugent in particular of deliberate distortion of the facts, and they say no fewer than 114 separate instances of willfully ignored or sought to interpret the evidence in a manner and to an extent inconsistent with the record. And you will see how dealing with that particular aspect in paragraph 47, firstly identified a complaint of judicial bias as one of a constitutional matter. And it says in the paragraph 47, a complaint of perceived bias is a constitutional matter. There are several reasons for this, but stating a few should make the point. Judicial authority is an integral and indispensable core of our constitutional architect. Supreme law vests judicial authority in the courts. It commands that courts must function without fear, favor, or prejudice, subject only to the Constitution and the law. And then further down it says, thus when a litigant complains that a judicial officer has acted with bias or perceived bias, he's in effect saying that the judicial officer has breached the Constitution and their oath of office. This is so because courts are final arbiters on the meaning of the Constitution and the law, a high duty that must be discharged without real or perceived bias. The issue is one of grave constitutional concern that demands an unfailing attention of the court seized with the complaint. And you'll also see later on in paragraph 57, paragraph 58, and paragraph 61, the court, I mean, really just goes to explain the gravity of an allegation of bias. And we know now that you can actually raise a bias allegation based on the code of conduct. And in paragraph 62, that's where the court then talks about the presumption. Sorry. It's paragraph 68 and 69, where they then talk about the presumption of judicial impartiality and double requirement of reasonableness. About that presumption, then they deal with what that means, but in the context of judicial impartiality. I have made submissions on those presumptions. I stand by them, and I do not believe that it is correct to say that when a complaint of judges is made, that presumption is inapplicable. The starting point should always be a judge is presumed to have integrity. And you'd have seen in the Bennett case where the judges said judges are presumed to take their job very seriously, and so seriously that the code of conduct regulates both their private and their public life, because it's important that judges are held to that standard of probity and integrity. So the presumption must always be, that's why it shocks the conscience of society when a judge is alleged to have breached the code of conduct, because it is not presumed, it is not lightly presumed. The judges are always presumed to be with integrity. And I'm saying it will help incredibly the JSC to appreciate that tool, that principle, which comes from the Constitution itself, which is that judges take their jobs very seriously, and they would not likely engage in misconduct complaints. So when you engage, and that presumption is very important, because it is, especially because judges are human beings. They interact with ordinary folks like us in churches, in different places. And when a judge meets an ordinary member of society, and the judge recognizes one appearing in this particular case, for example, and an ordinary member of society says, Justice Ledwaba, I see you were presiding over that case of Hlophe. That must be an interesting case. Judge President Ledwaba is simply going to nod his head and say, yeah, sure. But nothing Judge President Ledwaba reads in the papers, nothing he hears from his wife or his children or anybody could influence him in how he handles this case, because he's presumed to be impartial, irrespective of who says something to him about that particular case. It's presumed. I'm saying that is the standard against which the complaint should have been analyzed and looked at. And I did refer the court to the Canadian approach, which says look at whether the conduct is such that it is destructive of the concept of impartiality, independence, and integrity. It's a forward-looking test. It says, if we keep this judge as a judge, do we lose public confidence in the office of the judge or the judicial independence? Do we weaken the trust the judiciary has in the judges to resolve these complaints? To be arbiters of disputes. And that's a forward-looking sort of test. It allows for the court to even look at questions about the desirability of keeping a judge. For example, in one case in Canada, a judge had lied or was found to have lied in the course of giving giving an answer when he was appointed. So during his appointment process, he had been representing drug dealers mostly, and in one instance he was in an office with one of the accused drug dealer, where he was seen putting a note in his pocket that he got from that drug dealer. And when he was asked to explain what that was, even though the video did not have sound, even though the video did not have any very clear clarity, the answer was not impressed. The conduct committee of Canada found the answers he gave in explaining that particular note unsatisfactory. And they said, no, but what do we say about this in society with a judge who is found not to have the kind of credibility in giving evidence as this judge? So they said, well, the very giving of false evidence in a tribunal or in a court would impugn the public confidence, which is a very important component of whether or not you remove the judge or not. Then let me deal with the last aspect, because I'm still mindful of the fact that my learned friend Mr. Stagi will come and deal with the last bit of the arguments. In the my learned friend for the speaker suggests or submits that the order we seek is an incompetent order. Well, of course, when the matter is not before the National Assembly, and I accept that perhaps because the matter the matter is before the National Assembly because that report has been sent to the National Assembly. But I accept that when the matter started off in the interim, during the interdict phase, the National Assembly could have taken that position. But now we know that the National Assembly takes the view that it is not obliged to conduct an inquiry in accordance with its own rules, in accordance with its own procedures for purposes of Section 1771B. That the processes are bifurcated, they are sort of are separate in such a way that the constitutional obligation to make a finding is that of the JSC, and the National Assembly must simply vote on the finding of the JSC. But we submit with respect, that's an incorrect reading of 1771B. And if Judge President Hlophe is going to, which he will if he's directed to go to the National Assembly, he will have no choice. But if he goes to the National Assembly, and the National Assembly's position is simply, we're not going to get involved in trying to hear you, then we are back to where we started in the interim order. In the interim order, these are the allegations made in paragraph 32 of the founding affidavit. Sorry, starting in paragraph 29 of the founding affidavit. And it's on page 00124. This is where Judge President Hlophe says, it's against the National Assembly. I say that the resolution, it is constitutionally enjoined to adopt in the event of a finding of gross judicial misconduct by the JSC must be based on the correct facts, admissible and credible evidence, and a proper application of the law. To ask the National Assembly to exercise its powers in terms of Section 1771B on unlawful decision of the JSC is to ask the National Assembly to act unconstitutionally. Then we say the process of the JSC, of the National Assembly, is in any event not designed to review and overturn the JSC process. While it has elements of a legal process, the National Assembly process is entirely political. But a vote of the National Assembly must be premised on the fact that the JSC process itself was lawful and its findings reflect the correct legal and factual position in relation to the issues of gross judicial misconduct. And then in paragraph 32, we say in the circumstances, the National Assembly should stay its proceedings pending the outcome of this application in Part B, and that's why it stayed out of the proceedings. But we go further. We say, Judge President Hlophe goes further. He says, I am in any event not aware of any rules having been adopted by the National Assembly to regulate the process for the adoption of a resolution removing a judge from office. If such rules exist, I would request that they are made available to my legal team as a matter of agency. In the event that the National Assembly has no rules to regulate the removal process involving a judge, I would add that the absence of rules is a further basis for staying the National Assembly processes pending the outcome of my application for Part B. To expose me to the risk of a National Assembly process without any rules would be unfair, unlawful, and ultimately undermine judicial independence, the integrity of the judicial office in violation of Section 165 of the Constitution. So what Judge President Hlophe is saying, they speak what is submitted on behalf of the Speaker is not reassuring. Speaker is not coming here to say, when the matter comes to the National Assembly, we've got a fully established process of engaging with the issue. The impression given in argument is that the National Assembly is bound by the JSC finding. And with respect, that is incorrect. Because the National Assembly process is a different constitutional process, separate from that of the JSC process. It simply doesn't sit to endorse the findings of the JSC. And that must be correct, because the threshold that is established by the Constitution for the impeachment of a judge is deliberately designed to be cumbersome. It is designed to make it difficult for politicians to remove a judge. That is why the argument that is given a hearing before the Judicial Conduct Committee, the Judicial Tribunal, and the Judicial Commission doesn't cut it. Because the process itself for the removal of a judge is designed to be difficult. And if you open the doors by suggesting that politicians must simply vote on the findings of the JSC without applying their minds to what it is they are voting for, is simply to ask them to vote on an informed basis. And I say uninformed not because I don't suggest that they would not have read the finding of the JSC. They would have, but process of Parliament ought to be engaged in terms of Section 1771B in order to come to its own conclusions about whether the judge involved is in fact guilty of gross judicial misconduct. So here is a problem. The parallels argument, coming back to the and I'm closing my submissions, save for one aspect. The parallels problem, and I appreciate that what we've been trying to do, Honorable Justices, is to make submissions that are not intended to frustrate the resolution of this matter. That is why my learned friend could read from our arguments. We engaged with these issues quite neutrally, trying to say what is the best way in which there is credibility. We affirm Judge President Hlophe's rights, as well as we affirm the rights of the public to accountability and to judicial independence and to public confidence in the judicial office. How do we do it in a way that complies with the law? If the parallels argument is correct, then of course, what is submitted is that we can't go anywhere. There is a legal impossibility, because you can't make the call of whether or not Judge President Hlophe is guilty. It is not the duty of the court to do so. That issue has been assigned to the JSC, so you can't make that duty. You can't make that call. At least the one of the constitutional institutions that we have in the Constitution that can make that call, Parliament is one of them, or the National Assembly is one of them. And we say, to the extent that Parliament or the National Assembly to the extent that the Judicial Service Commission, by its own concession, and I accept that my learned friend for the JSC, the senior leader of the JSC, did submit the argument that the matter must be remitted back to the JSC. So that submission we submit would be the normal response. But in the event that there is in fact a paralysis, as my other learned friend from the JSC submitted, then of course, what do? We said initially in our notice of motion, stay the proceedings. We're not persisting with that. We're not asking for you to stay the proceedings, because we understand that these allegations are allegations that go to the core of judicial independence, the integrity of the judicial office, and the public's confidence in the judiciary, who now remains unparalyzed by its own incompetence, its own constitutional incompetence, other than the JSC. Parliament has not dealt with this matter. And we say they have a broad constitutional responsibility, including of oversight. And it may well be that during the inquiries that they make, they are themselves placed in a position to make regulatory or statutory amendments that may help in the protection of judicial independence, and that may help the JSC to refine its own processes insofar as it is a National Assembly that has an oversight duty on the functioning of other institutions of government, or on the function of other organs of state. We make those arguments in our heads of arguments. We stand by them. And we say it is no answer for the Speaker to simply say, well, the matter is not here yet. The court is now faced with the situation where they ask themselves, if we uphold the parallels argument, how do we get around resolving this issue? This hits right at the door of our own standing as judicial officers. We now are faced with a situation where we must resolve this issue. And we say, try and find a resolution that complies with the law. Do not accept an argument that you can use unconstitutional methods in order to achieve a constitutional outcome, which is what the first arguments on composition would suggest. But so in your interpretation, and this is the other fault of the JSC, in their interpretation of the rights that are engaged in Judge President Hlophe, they don't go to the constitutional provision that directs how to interpret constitutional rights. They don't go to that provision to say, how do we interpret a law that implicates the rights of an individual you are dealing with? And just the failure to refer to Section 38 of the Constitution is in itself a failure to apply the correct law. Because if they'd done so, they would have said, well, look, to the extent that we're now left with one aspect, Judge Hlophe's utterances, we're not left with an act of persuasion because that is out of the window. Here's the specific evidence is that he did not persuade us, not from the point of view of effect, but from the point of view of process. What was the process of influence that was adopted in order to, the process of the alleged influence that was adopted? It was persuasion. That is taken out. What we're left with now is that in the presence of judges who were handling a pending case, Judge President Hlophe made what they regard as inappropriate remarks. That's why he must be removed. But when you look at the content of those inappropriate remarks, they could never, ever influence a judge to rule in any direction. In any direction. They were not on the merits. They were barely detailed to the extent that any principle was discussed. And if one accepts Judge Nkabinde's version, as soon as she raised the impropriety of the conversation, her answer is, Judge President Hlophe said, my sister, I'm not trying to influence your or to interfere with your job. I'm just saying. You know, and he apologized. In fact, she says, and he apologized. Sorry. That should have ended the matter. And Judge Nkabinde says, look, when I looked at the matter, I had been exposed to a process in terms of which I knew how to apply a matter to a colleague or a process to a colleague who is acting inappropriately towards me. I thought I dealt with it. Judge Jafta says the same thing. But with Judge Jafta, the issue of rebut wanted to acquire some significance. It's totally insignificant. There would have been no opportunity for Judge Jafta to rebut Judge President Hlophe. He doesn't say so. When you look at it, the totality of his evidence, the only time he thought there was something inappropriate was when the conversation had taken place, weeks after that. That is the only time. He, in fact, walked Judge President out of his office to visit Judge Ngobo. And that is when they met Judge Nkabinde with Judge Madala outside the corridors. And that's when Judge Hlophe says, oh, Judge Nkabinde, I even congratulated you since you became elevated to the bench. Next time I'm here, I will make sure that I swing by so I can have coffee with you. That is the narrative that is missed in the whole thing. The first meeting was there with Judge Nkabinde. And Judge Nkabinde's answer to him was, oh, good to see you. How are your things in the Western Cape? And how are your things in the Western Cape means, how are your troubles in the Western Cape? And everybody knows the troubles, Judge President, the tribulations and trials that Judge President Hlophe has faced in the Western Cape. And so those judges, as colleagues, were asking a colleague how his experience was. And so when they meet subsequently, that is discussed, that aspect. On the issue of the mandate, we know never meant that to debate a mandate of any legal principle. Judge Hlophe explains what it is, and you've got to find that he was lying when he explained what it is that he meant by mandate. But you can't find that he was lying, because on the same day that he met Judge Nkabinde, he had a meeting of the local organizing committee involving judges, Commonwealth judges in the Western Cape. He was chairing that committee. There were 4 judges who were involved in it. He mentions them by name. That were present in the afternoon of the meeting that he had met with Judge Nkabinde. He had met with the Chief Justice. And the conference that he mentioned actually took place. It actually took place. So it can't be suggested that there was some premeditation, because the premeditation doesn't come with the phone call. The premeditation must come at the time that they met, on the day that Justice Nkabinde and Justice Hlophe met, when Justice Jafta was walking Hlophe to Judge Ngobo's office. That is where the premeditation would have come. So, and in any event, there was no evidence led to at the tribunal to suggest that there was premeditation. No evidence led. It's just call it a thumbsuck. Honorable Justices, let me say finally on the issue of costs. We seek no relief against the FUL, as you would have known. We accept the Constitutional Court justices are entitled to be involved in these proceedings. The practice, as I recall it, between the justices of the Constitutional Court and Judge President Hlophe has been to say, well, you know, each party pays its con. They all come from the same government anyway. But I would urge the court to also look at the impact of a cost order on judicial independence, on the integrity of a judicial office, and what a cost order does, especially by a litigant who has had this privilege that the FUL has had of coming into a case when they are not actually respondents in the true sense and meaning of the word. You must just look at what a cost order does to a judge. If Hlophe, for some reason, has no money to pay, we know what it does. Could be sequestrated, could be exposed to embarrassing moments because of a cost order. Would submit that in deference to the principles of judicial independence, the integrity of the judicial office, no orders of the to the cost are granted against Judge President Hlophe. In fact, because of the nature of the case itself, would submit no orders as to cost are actually met. I would want to say something about whether the FUL, if the FUL arguments were lost, whether they shouldn't be settled with the cost order. But I'll leave that, and they will benefit from the benevolence of Judge President Hlophe's acceptance of this particular issue. But those are the submissions that we make. My learned junior will address the court on a different aspect relating to the issues that he dealt with in his own address when he addressed the court. Justices, unless there are any questions, those are the submissions I am making on behalf of Judge President Hlophe.
No questions, thank you.
And just to say, we really appreciate the decorum with which the court has conducted this particular hearing for the moment. Mr. Stagi will take over.
Thank you. Mr. Sidaki can continue. Yes, you may continue.
Thank you, Justices. I am mindful that we might have gone beyond our time limit, and I have prepared an address for the court, and I would urge for an indulgence of 30 to 45 minutes, Justice Ledwaba, with your permission.
Please try to limit it to 30 at most.
As the court pleases. Thank you.
On the time that was allocated to finish at Koratu, but there were some questions by the court. It would be appreciated if you can limit it to 30, and if you can be done by about 1 o'clock. But continue.
As the court pleases. Thank you, Justice Ledwaba. I begin by referring to the Constitutional Court decision in Camps Bay Ratepayers and Residents Association versus Harrison and another. It's a 2011 Volume 2 BCLR 121 CC decision, also available at 2011 4 SA 42 CC, where Brand, acting judge, writing for the court in dealing with an argument which raised issues concerning the principle of stare decisis, to stand by decisions previously taken, held as follows at paragraph 28. Considerations underlying the doctrine were formulated extensively by Harlow and Khan. What it boils down to, according to the authors, is certainty, predictability, reliability, equality, uniformity, convenience. These are the principal advantages to be gained by a legal system from the principle of stare decisis. Observance of the doctrine has been insisted upon both by this court and by the Supreme Court of Appeal. And the paragraph then goes on, and at the last a few lines, it is stated, stare decisis is therefore not simply a matter of respect for courts of higher authority. It's a manifestation of the rule of law itself, which in turn is a founding value of our Constitution. To deviate from this rule is to invite legal chaos. I refer further to what has become a locus classicus, the Affordable Medicines Trust and others matter, and I refer to paragraph 49 of that decision, which says the exercise of public power must therefore comply with the Constitution, which is the supreme law, and the doctrine of legality, which is part of that law. The doctrine of legality, which is an incident of the rule of law, is one of the constitutional controls through which the exercise of public power is regulated by the Constitution. And then, of course, the paragraph goes further. I'm not going to read the whole paragraph. I cite these legal principles, my lords, my lady, which are constituents of the cornerstone of South African jurisprudence, as an attempt to refocus on what's really at issue in this matter, the rule of law. Now, at paragraph 74 of its report, the Judicial Conduct Tribunal had this to say, as a prelude to finding Judge President Hlophe guilty of a gross misconduct. It says, we have already made the point that the concept of a charge or a charge sheet is not a requirement in these proceedings. And because these are not criminal proceedings, the requirements that the charge must be clear and unambiguous, or that the alleged conduct must be wrongful or unlawful, or that there should be mens rea, do not find application in these proceedings. What we are concerned with here are issues of judicial probity and ethical standards rather than rules of law. It was the tribunal, we submit, which served Judge President Hlophe with charge sheets. When material flaws were pointed out, not taking technical points, but in line with conventional legal scrutiny, the tribunal jettisoned at judgment stage the charge sheets that it had introduced. We submit that the tribunal said it is not a requirement that the charge must be clear and unambiguous. We submit that is irrational. The tribunal said it is not a requirement that the alleged conduct must be wrongful or unlawful. The question is, how does one establish guilt without an element of wrongfulness or unlawfulness? We submit that finding was irrational. The tribunal said it is not a requirement to establish mens rea. How else does one prove guilt, even on a lower threshold of balance of probability, without an element of mens rea? We submit that finding is irrational. Doing away with the requirement for mens rea means that guilt is established on a basis of strict liability that is guilt without fault. We use Article 2 of the Code of Judicial Conduct, which came into effect after the events under consideration in this matter, as a comparative tool on this topic. It provides that any willful or gross negligent breach, of this code is a ground upon which a complaint against a judge may be lodged in terms of Section 14 of the JSC Act. Thus, the Code of Judicial Conduct requires, firstly, a determination of a breach of an established rule, and secondly, mens rea, that is, that the breach occurred either willfully or as a result of gross negligence.
But Advocate Sidaki, it says willful or gross negligence. And then on the issue of gross negligence, what is a test? Is it subjective or objective?
It would be objective. I would submit, my lord.
Objective is intention a requirement.
Well, my lord, I submit. It's a point that I'm in to deal with later in my address. But perhaps to say, and I'll try and truncate it, to say that the charge here, the accusation here, is an attempt to commit an offense or to commit something. Now, to establish an attempt, I would submit that then one would require a subjective test in order to establish attempt, because attempt cannot happen negligently. That would be my truncated submission, my lord. Okay. Even where statutory provision contains no express mention of the mens rea requirement, our courts are reluctant to interpret it as not requiring mens rea. This was clearly expressed by Oregon J. in S. versus Kutsia and others, 1997, 3 SA 527. Constitutional Court. Oregon J. quoting from the decision of State versus Ehrenstein, where it was held as follows. In view of such general maxims as nulla puna sine culpa and actus non facit reum nisi, mens sit rea, the legislature, in the absence of a clear and convincing indications to the contrary in the enactment in question, is presumed to have intended that violations of statutory prohibitions would not be punishable in the absence of mens rea in some degree or other. In the case of Judge President Hlophe, the punishment is impeachment. The presumption against strict liability has subsequently been constitutional in Democratic Alliance versus African National Congress in another decision in 2015, Volume 2, SA 232, Constitutional Court. A case concerning alleged breach of Section 89(2)(c) of the Electoral Act. In that case, the Constitutional Court held at paragraph 154 that there is an interpretative presumption that a penal prohibition includes a requirement of fault. Judge President Hlophe was charged with an attempt towards a certain conduct, and we submit that as a matter of law, attempt should be established subjectively to establish attempt. Then the tribunal said, what we are concerned with here are issues of judicial probity and ethical standards rather than rules of law. Again, by way of comparison with the Code of Judicial Conduct, we refer to Article 32A, which provides that this code must be applied consistently with the Constitution and the law as embodied in the common law statute, and it goes on. We submit accordingly, by not applying the rules of law, the tribunal's decision is irrational. And then the tribunal pronounced that the Judge President Hlophe was guilty of gross misconduct. Nowhere in the scheme of the JSC Act is this power given to the tribunal. Section 26 of the JSC Act does not endow the tribunal with such a power. This is a power expressly given to the JSC, the Commission, under Section 20, subsection 3 of the JSC Act, and under Section 1771A of the Constitution. A power to be exercised at a properly constituted meeting in terms of Section 178 of the Constitution. We submit that by exercising a power expressly given to the JSC, the tribunal acted ultra vires, outside its power, and we submit that that was irrational.
Mr. Siddiqui, can I ask you this? If you look at Section 26, the object of the tribunal is to inquire into allegations of gross misconduct, and then to submit a report. So, are you saying that that in that report they can't say that this amounts to gross conduct? And you say that the statutory scheme doesn't entitle them to do that?
Well, my lady, my response to that would be that the tribunal actually concludes by making what one would say a legal pronouncement. They find Judge President Hlophe guilty of gross misconduct, and we submit that that was beyond the remit of the.
So if they'd said, well, this is consistent with gross misconduct, that would have been acceptable. If this is, if they have to inquire into gross misconduct, then that is their mandate. Inquire into it, and you say, well, they can't come to that conclusion.
Well, they can come to factual conclusions, but they may not make a legal conclusion. So to pronounce guilt of gross misconduct, that is specifically provided for to be pronounced by the JSC. And we submit, my lady, that that stretched beyond the scope of their power.
Right, I've noted that.
I refer the court to the case of Police and Prison Civil Rights Union and others versus Minister of Correctional Services. It's a 2008, Volume 3 SA, page 91. It's an Eastern Division decision. Paragraph 66 dealt with the issue as follows. The first set of grounds of review relate to the lawfulness of the administrative action taken against the applicants. At its most basic and in general terms, the right to lawful administrative action means that administrative actions and decisions must be duly authorized by law. And preconditions attached to the exercise of power must be complied with. Administrators may only exercise powers that have been lawfully reposed in them. And when they exercise such powers, they are required to stay within the four corners of their empowerment. They have no free hand to stray outside of the boundaries of their empowerment. The fifth respondent only had power to discipline in terms of the prescribed procedure. He had no power to abandon it and discipline employees in terms of an ad hoc procedure that he decided was expedient in the circumstances. By doing so, he violated the fundamental rights in the applicants to lawful administrative action because he was not authorized to take the administrative action that he did. And the court concluded that the ground of review contained in section 62A, Roman figure I of PAJA had thus been established. We also refer to the case of Rue versus Health Professions Council, South Africa, and another. It's a 2012 All SA, page 49, decision of the Supreme Court of Appeal. And the facts and legal principles enunciated therein we submit are apposite. The Health Professions Council of South Africa, the HPCSA, was requested to investigate a complaint against the appellant, Ms. Rue, a clinical psychologist, into allegations of unprofessional conduct and institute an inquiry into her conduct. It was decided by the committee of the preliminary inquiry of the Professional Board for Psychology that an inquiry into the conduct of Ms. Rue would be held in respect of an allegation of having unprofessionally assumed multiple relationships when dealing with a client. The pro forma complainant initially prepared a charge sheet which referred to the multiple relationships charge, but this was subsequently replaced by a new charge sheet which obtained two charges, which contained two charges, the multiple relationships and a further one, misdiagnosis charge. The issue before the SCA was whether the pro forma complainant had the authority to prefer charges against a health practitioner which were not authorized by the committee of the preliminary inquiry. Counsel for Ms. Rue had contended that the pro forma complainant had exceeded his authority when he included the misdiagnosis charge sheet, as he was restricted to formulating a charge as determined by the committee. The SCA stated that this implicated the principle of legality. The SCA made the following key findings. At paragraph 27, it says, in the result, the High Court erred in finding that the pro forma complainant had the power to determine the ambit of the inquiry, including the specific charges to be preferred. And in paragraph 29, SCA stated the official acting on behalf of the HPCSA in deciding to add the additional charge was engaging in administrative action. His decision clearly falls within the definition of administrative action and is in the ordinary course subject to review for lack of statutory authority in terms of section 6 of PAJA. The principle of legality requires that power should have a source in law and is applicable whenever public power is exercised. Public power can be validly exercised only if it is clearly sourced in law. That's paragraph 31. And then in paragraph 32, the last paragraph I'm going to refer to, it says, the principle of legality dictates that administrative authorities such as the HPCSA cannot act other than in accordance with their statutory powers. The decision of the pro forma complainant was not and has offended against the principle of legality. The decision had to be reviewed and nullified for want of statutory power. Submit, Justice Victor, the same principle would apply in relation to the question you posed.
Yes, Mr. Sidaki, I still have a difficulty if you look at 26.1 Roman 4. If they make a determination on the merits and you read that with subsection 3, when considering the merits of any allegations against a judge, the tribunal must make its determination. If you say they can't recommend, they can just say this conduct is consistent with gross misconduct.
Well,
You know,
my lady,
the statute power is there. They've got to come to some conclusion.
my lady, I
Balance the probabilities.
submit with respect, my lady, that when pronouncing on guilt, because there are elements to guilt, and there are legal elements to guilt, to establishing guilt, that the tribunal was not endowed with. And
So what is section 26(1) Roman 4, A4 mean? Making a determination on the merits. You say that doesn't include guilt. They make a full inquiry and they say that this conduct is consistent with guilt.
I submit respectfully, my lady, before one can establish guilt, one would have to engage first in the elements, legal elements of the charge, and the tribunal their function was merely to deal with facts and merits and not delve into legal issues, and that by pronouncing on guilt, they were then venturing into a terrain that was specifically reserved for the tribunal.
Thank you, Mr. Siddiqui. Thank you.
And so they would deal with the merits of the facts, as it were. The tribunal said the following at paragraph 122, that they consider it their duty, even before pronouncing the verdict, to vindicate the integrity of the complainant judges. We submit this was not a finding sourced within the scope of the tribunal's powers. However,
So is that a reviewable issue or an appeal issue?
My lady, I submit that is another indication of irrationality. That finding is not rationally connected to the outcome of the matter.
Thanks.
And furthermore, and we submit more worryingly, it is when would this sense of duty to vindicate the complainants have a reason? We'll likely never know, because there is no evidence from the decision maker. The tribunal members are the only persons who would have first-hand knowledge of the facts. They have not provided evidence by way of affidavits to explain these and other pertinent issues in relation to the issues raised in the papers.
Mr. Siddiqui, has there ever been a situation where, in an appropriately analogous context, the members of a tribunal independently provide affidavits of what they thought when they came to their collective decision? They provide a report. That's what they think. Are you suggesting that there's some duty on them to amplify that?
My Lord, I would refer to the cases that I referred to in my address in chief, where that was the finding of the Supreme Court of Appeal in Mail-in Guardian versus President of South Africa, where the court lamented that there had not been a report that had been compiled by two judges and provided to the president. And the court said that those judges should have deposed to affidavits explaining the situation and the reasoning and circumstances around their report.
Is that analogous to this situation?
My Lord, I submit that it is, because this was administrative action being undertaken, and these are the decision makers, and Mr. Chilwane, for instance, makes reference to facts that are beyond his knowledge, that cannot be accepted as probative. The value of which of that evidence cannot be regarded as probative. So we refer to those judgments, my Lord, von Orbo, Merlin Guardian. The Merlin Guardian is the SCA and Constitutional Court decisions, and various others as cited in our heads of argument.
Yes. Right.
We have submitted to this court that there are fatal irregularities with the affidavit of Mr. Chilwane, which constitutes the mainstay of the opposition to the review application. The respondents have not responded at all to any of the challenges raised in this regard. Accordingly, Mr. Chilwane's affidavit falls to be excluded, except perhaps insofar as certain portions are confirmed by Justices Meyer and Betse. But those portions only relate to why they did not attend the meeting of the 25th of August. They have not confirmed the delegation point. They haven't confirmed the appointment point. Again, my lords, my lady, it would have been incumbent, citing those cases on, in this instance, Justice Mba, to have deposed to an affidavit to explain how it came about that he sat on the JSC. This court can only speculate, and will submit that the evidence of Mr. Chilwane is unhelpful in providing this court with reliable evidence upon which it can decide. The SCA made it clear in Mail and Guardian that in such an instance, the facts have not been established by acceptable evidence. Accordingly, no probative value may be attached to the affidavits by 1st and 11th respondents we submit. The case in Prince versus Minister of Correctional Services, it's a judgment 2007 on judgments online, 20443 SE. It's cited at paragraph 546 of our heads of argument. Plaskett J, as he then was, held as follows at paragraph 8. When the hearsay and opinion evidence is excluded from consideration, one is left with the largely unchallenged evidence of the applicant. Justices, these are legal arguments and legal submissions made after having conducted a diligent forensic examination of the facts and the evidence contained in thousands of pages constituting the record before this honorable court. And after conducting extensive legal research, in the execution and performance of our respective duty as Judge President Hlophe's legal counsel and officers of this honorable court, they are not technical objections and generalized complaints as described by our learned friends. These submissions are grounded in legal jurisprudence, and they establish prejudice and materiality, we submit. Some of our learned friends feature in some of the case law that we have cited as advancing the very same arguments in the courts. Procedural points taken are grounded in law. We submit, as Ngobo J. held in Masetla versus President of Republic of South Africa, there is indeed an interrelationship between failure to act fairly and arbitrariness. In this sense, the requirement of the rule of law that the exercise of public power should not be arbitrary has both a procedural and substantive component. We refer to the matter of Speaker of the National Assembly versus DeLille, 1999 Supreme Court of Appeal decision, paragraph 14, where the court held that the Constitution is the ultimate source of all lawful authority in the country. No parliament, however bona fide or eminent in its membership, no president, however formidable be his reputation or scholarship, and no official, however efficient or well-meaning, can make any law or perform any act which is not sanctioned by the Constitution. Any citizen adversely affected by any decree, order, or action of any official or body which is not properly authorized by the Constitution is entitled to the protections of the court. Mogoro J. summarized these aspects of the rule of law in her concurring opinion in President of South Africa versus Hugo, paragraphs 39 to 40. And I'll truncate my submission, where she says the need for accessibility, precision, and general application flow from the concept of the rule of law. A person should be able to know the law and be able to confirm his or her conduct to the law. Further, laws should apply generally rather than targeting specific individual. FUL, we submit, prides itself of having taken the JSC to court and successfully reviewed and set aside the 2009 JSC decision. FUL's papers in that matter are to be found on case lines 0082609 to 0082954. The 2009 case was brought partly on the basis that, and I'm not going to refer to everything, but partly on the basis that the JSC had a desire to avoid cross-examination. That was their allegation. They said the JSC acted contrary to the standards of fair administrative proceedings. They said the JSC must act with reference to the facts and the law, including the law of evidence, exercise its constitutional powers and duties in terms of Section 177 of the Constitution, and find that a case has been made out by the complainants or that it has not. They stated further, this is a proper cause that the JSC must take in terms of Section 177, read with the rules. It cannot avoid it by recasting the process as a preliminary inquiry. Further, they said, in exercising its constitutional duty, it must apply the law of evidence regarding the resolution of conflicting factual versions. The JSC cannot abdicate its responsibility because the complainants and those against whom complainants are made are judges. Further, the FUL said, to the extent that the JSC failed to take into account crucial evidence which was before it, the decision to finalize a complaint and counter-complaint stands to be set aside under PAJA and on the constitutional review grounds. The FUL also stated no valid majority had been achieved by the JSC on 15 August 2009. They stated the participation in the decision of 15 August 2009 of Commissioner Ndoni was improper. Another of the new presidential appointments to the JSC was Ms. Ndoni, the president of the PLA. She had, in this capacity, made public pronouncement on a case before her appointment to the JSC. So that was an attack by the JSC on the Commissioner Ndoni. Further, the JSC stated, upon the President announcing his intention to appoint Ms. Ndoni, the Democratic Alliance, with whom the President consulted on the appointment, raised concern about her appointment based on the fact that newspaper interviews and articles have been revealed that, in her opinion, Justice Hlophe was innocent. And then it goes further. They attack the absolute majority established in the JSC. So we submit, my lords, my lady, that the legal basis upon which Judge President Hlophe has brought this review application against the JSC is not dissimilar from that successfully exercised by FUL against the JSC some 13 years ago. The purpose of FUL's application then was to review and set aside 4 decisions made by the JSC that FUL characterized as unlawful, unconstitutional, irrational, procedurally unfair, and accordingly invalid. A summary of the causes of action relied upon by FUL then covered a whole 4 pages. In response to protestations by Commissioners Semenya and Ndoni that their respective membership of Advocates for Transformation and Black Lawyers Association did not disqualify them from participating in JSC proceedings dealing with the matter, FUL submitted that Commissioners Semenya and Ndoni could not be said to have been impartial, notwithstanding their professional independence. They went further to say, at paragraph 71, the contention that the 2 commissioners cannot be held responsible or accountable for the views of their organizations is an inversion of a principle applicable to voluntary associations and political organizations, that individual members are bound by the decisions of the majority. That principle presumably applies to AFT and BLA, but that does not mean that individual members such as Commissioner Semenya and Ndoni, who publicly express support for the views of the organizations, can shield behind those organizations or disavow any responsibility for those views when they are held accountable for those views and when there is a reasonable apprehension that those views could improperly have influenced decision-making at the JSC, end quote. There are similar issues we submit before this honourable court concerning the Premier. And the argument being made by ourselves is akin to that advanced by FUL in 2009. So we ask, why the bitter criticism against Judge President Hlophe? Why the double standard and the venomous attacks from FUL? Against this background, there can be no doubt that the current litigation is grounded on a sound, factual and legal basis and has strong prospects of success. FUL was not criticized by the courts for raising these very important issues that we are raising now. We submit there is a plethora of evidence before this court, compelling evidence we submit, indicating that the rule of law, having regard to the full spectrum of this case, has not been properly observed. The cumulative effect thereof is material and prejudicial, we submit. It's prejudicial to Judge President Hlophe and is also a factor to be considered. I'm in my concluding.
Sidaki, you said you wanted 45 minutes. I've given you the 40. If you are left with 5 minutes, I hope you'll be able to wrap up in 5 minutes.
As the court pleases.
Because you are at the stage of reply, not of arguing now. Okay.
Thank you, my lord. I refer to the case of acting chairperson JSC versus Premier, paragraph 25, where the Cluted JA stated as follows. The arguments advanced on behalf of the appellants, that is the JSC, lose sight of the fundamental significance of the findings made by the court quo that will be confirmed by this court. The declaratory order had to be made. There was no discretion. Section 1721A of the Constitution is in imperative terms. And then the paragraph continues. We submit, going back to where I started, certainty, predictability, reliability, equality, uniformity. These are the principal advantages to be gained by a legal system from the principle of stare decisis. Sorry for not getting this right, Justices. Stare decisis is therefore not simply a matter of respect for courts of higher authority. It's a manifestation of the rule of law itself, which in turn is a founding value of our Constitution. To deviate from this rule is to invite legal chaos. We conclude by invoking the aphorism, hard cases make bad law. The mischief with the reasoning in the tribunal decision, particularly paragraph 74, which ultimately forms the basis of the JSC outcome, is that it sets an insidiously low standard by which to measure the actions of any accused judge, and by extension, the standard by which any judge can be removed from office. The tribunal decision properly considered endorses a position where a judge can be removed from office even in circumstances where the charges are unclear and ambiguous, where the actions of the judge are not wrongful or unlawful, and where no fault against the judge's actions or conduct have been established. If confirmed, that would be the precedent for the future. Lastly, my lords, my lady, the Constitution itself, and not its judicial servants, is supreme. Central to the current inquiry is the rule of law. For the Constitution to function as the supreme law of the land, effect must be given to its principles, regardless the identity of the protagonists in the current dispute. My lords, my lady, I appreciate your indulgence. Those are my submissions in reply. Thank you.
Thank you, Mr. Sidaki. Also, on behalf of my colleagues sitting with me, I would like to thank the council.
But before the court adjourns, I'm constrained to point out that counsel for the respondents have misapprehended the approach of the BLA on three aspects, and one is an important one.
No.
Because
what's your point, Mr. Don? What's your point?
Sorry, one of them is an important one. The misapprehensions.
Wait a minute. You've been given an opportunity to argue on behalf of the BLA. You presented your argument, and the applicants have replied. So are you saying you are entitled to reply?
No, I'm not entitled to. I am begging the court to allow me to deal certainly with one of the misapprehensions.
That is where
the respondents, because it involved.
The first started by asking the court's indulgence, not just to.
No, I'm asking for an indulgence. I'm begging for an indulgence. Because I say that the respondents misapprehended.
Mr. Tony, wait a minute. If you ask for an indulgence, you must wait until that indulgence is granted.
Yes.
You ask for indulgence to do what?
to correct a misapprehension by Mr. Maleka, and that misapprehension involves the proper test for gross misconduct in section 177, as it was articulated by His Lordship Justice Sutherland, DJP. And we're saying that it may assist the court if this misapprehension is corrected, and it should take no more than 5 minutes to do so.
Would you mind maybe preparing hers briefly and circulate it among everybody?
Sorry, what the point was?
There's a point that you want to raise.
Yes.
Can't you just
The point was that
short it and circulate it among all the councils, and I'll give them an opportunity to respond to that in writing, because otherwise we won't finish.
Well, the point is simply that the DJP said that that gross misconduct was simply a
Mr. Donald, you want to finish this case? I'm going to give you 3 minutes to make your point. 3 minutes.
The point is simply this. Mr. Maleka contended that the BLA's approach to the question of gross misconduct created an inflexible rule, and the drafters of the Constitution in Section 177 left the decision to the JSC to decide what gross misconduct is. Mr. Maleka embraced the remark made by the DGP, Sutherland, to the effect that it was left to the JSC to make a value judgment. And we submit with respect that Mr. Maleka's statements and the DJP's remarks should not stand without any qualification. We contend that the legislature did not give the JSC an untrammeled subjective power to decide the meaning of gross misconduct by inserting its own values into their calculation. Given the history of law in this country, the drafters of the Constitution would never have given a subjective power to an institution in a matter as serious as removal of a judge, which always has potential to affect independence of the courts. The danger of doing this was illustrated by the administrative law debate in the 1980s around regulations under Public Safety Act, which allowed the Minister of Law and Order to order detention of a person without trial if, and I quote, in the opinion of the minister, the person was a danger to the public. So an activist, Janet Cherry, was detained without trial when the minister believed that she and her adult literacy project were a danger to public safety in that she was teaching adult black trade unionists to read. We submit that the kind of subjective value judgment, or that kind of subjective value judgment, is unacceptable to our Constitution, and in this case, the permissible value judgment is subject to objective stress test and constrained by the rule of law. So it must be made with reference to objective ground of gross misconduct, and that expression, gross misconduct, has legal meaning in our law. It's objectively determinable. Gross or serious misconduct warranting dismissal has objective criteria in our law, and certainly in the law regarding dismissal in our labour law. So the CCMA, the Labour Court, the Labour Appeal Court apply these criteria daily, and they must be guidelines for the principle.
That point, if you've made that point on your head, judges, you're repeating that point.
So the material criterion on which these courts rely is in Schedule 8, Item 7 of the LRA, which preceded the coming effect of the Constitution, and that's that there must be a rule which must exist, and the perpetrator should have known of the rule. And the only extant rules in this particular case which existed at the time were the direct prohibition in 1653 against interference with the courts in their functioning, and the implied prohibition in Section 165 sub 2, which impliedly prohibits threats to independence. So the answer to Mr. du Plessis is that the plateau necessary for removal of the judge is violation of these sections. And absent violations of these sections, there is that plateau has not been reached. And if the BLA is then correct in its argument that originally raised, failing proof of violation of these sections, there are no other objective factors that can lift Hlophe J's conduct from misconduct to gross misconduct. And we hope that clears up the BLA approach and assists the court in dealing with the test in section 177, and in particular, DJP Sutherland.
Thank you.
I'm indebted to the court.
Judgment reserved. Court adjourns.
Thank you, my lord.
Thank you.
As the court please.